This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, so a lot of you have been asking about LeBron James tattoos. There was a lawsuit over LeBron James tattoos making it into the 2K games, 2K14, 2K15, 2K16, which were released the year before in 2013, 14, 15, respectively. So let's see what the judge has to say about this. Solid Oak Sketches brings this action against 2K Games and Take-Two Interactive, asserting a claim of copyright infringement pursuant to the Copyright Act. Following this court's granting of defendant's motion to dismiss plaintiff's claim for statutory damages and attorney's fees, plaintiff filed a second amended complaint. In it, defendants filed counterclaims for declaratory judgment pursuant to the Copyright Act and Declaratory Judgment Act, so that's like a counterclaim. The court denied plaintiff's motion to dismiss the counterclaims and denied defendant's motion for judgment on the pleadings. This court has jurisdiction, and the defendants now move for summary judgment pursuant to Federal Rule of Civil Procedure 56, requesting an order dismissing plaintiff's copyright infringement claim and an entry of a declaratory judgment in defendant's favor on their de minimis use and fair use counterclaims. Plaintiff has cross-moved to exclude a 4-page expert report filed in support of defendant's summary judgment motion. The court has considered carefully the parties' submissions. For the following reasons, defendant's motion for summary judgment is granted. Plaintiff's cross-motion to exclude is denied. Take-Two is a major developer, publisher, marketer of interactive entertainment and video games. Defendants annually release an updated basketball simulation video game that depicts basketball with realistic renderings of different NBA teams, including lifelike depictions of NBA players and their tattoos. Plaintiff alleges that defendants have infringed its copyrights by publicly displaying works for which plaintiff owns copyrights. 5 tattoos are depicted on NBA players Eric Bledsoe, LeBron James, Kenyon Martin. I guess it's 5 tattoos across the 3 of them. Okay. In versions 2K14, 2K15, 2K16 of defendant's basketball simulation video game. According to defendant's expert, Nina Jablonski, I love that last name, Nina Jablonski, tattoos have been a part of human expression for thousands of years. In modern day, tattoos like the tattoos at issue in this litigation reflect the personal expression of the person bearing the tattoo and are created for that purpose. The tattoos reflect the player's personal expression. Solid Oak holds an exclusive license to each of the tattoos. Solid Oak is not licensed to apply the tattoos to a person's skin, and Solid Oak does not hold any publicity or trademark rights to the players' likenesses. The players have given the NBA the right to license their likeness to third parties, and the NBA has granted such a license to Take-Two. The players also granted Take-Two permission to use their likenesses. Now I'm going to do this the whole time. I'm going to be trying to say Take-Two or tattoo, and I'm going to get it wrong. LeBron James's child portrait tattoo was inked by tattooist Justin Wright and was copied from a baby picture provided by Mr. James. Mr. Wright knew and intended that when Mr. James appeared in public on television and in commercials or in other forms of media, that he would display the child portrait tattoo. It was Mr. Wright's intention that the child portrait tattoo become a part of Mr. James' likeness, which, according to Mr. Wright, Mr. James was and is free to use as he desired, including allowing others to depict it, such as in advertisements and video games. LeBron James's 330 and Flames, so 330 and Flames tattoo was inked by Deshaun Morris, also known as Sean Rome. He'll be referred to as Mr. Rome. At Mr. James' request, Mr. Rome created the tattoo by shading in the outline of and adding flames to the number 330, which had already been inked on Mr. James' arm. The number 330 represents the area code of Akron, Ohio. According to defendant's expert, Dr. Nina Jablonski, flames are a common motif used for tattoos. Mr. Rome stated that at the time that he inked the 330 and Flames tattoo on Mr. James, he knew that Mr. James was a professional basketball player with the NBA, and that it was likely Mr. James was going to appear in public, on television, in commercials, and in other forms of media like video games. Mr. Rome also stated that when he inked the 330 and Flames tattoo on Mr. James according to his requests, he knew and intended that Mr. James would display the 330 and Flames tattoo whenever he appeared in public, and that he intended that the 330 and Flames tattoo become part of Mr. James' likeness and part of his image. Sean Rome also inked LeBron James's Script with a Scroll, Clouds and Doves tattoo. The script tattoo was copied from a design in Mr. Rome's sketchbook. Solid Oak does not license the drawing used to create the script tattoo. According to Dr. Jablonski, birds such as doves have been a popular subject of tattoos since ancient times. As with these other tattoos, Mr. Rome intended the script to become part of Mr. James' likeness, etc. So the judge begins describing how the video game works and plays, that they included an accurate depiction of the physical likenesses, so there's really no dispute that they included the tattoos in the game. However, the tattoos are not displayed clearly during gameplay. So maybe when there's like a select your player screen or something, but not during gameplay. Therefore, the tattoos only comprise a minuscule portion of the video game data, only about 0.000286 to 0.0004.3%. So if you want the actual number, add another 2 zeros to that, the decimal place. Only that much percent of the game data is devoted to the tattoos. But when a player is selected, the tattoos are depicted on a computer or television screen at about 4.4 to 11% of the size that they appear in real life, due to the great distance from the camera that the player is depicted, and the resulting relatively small size of player figures. The tattoos appear merely as visual noise, no more noticeable than a simulated player's nose shape or hairstyle. The tattoos are subordinated to the display of the court and the players in the competition. The tattoos also cannot be observed clearly because they are often blocked from view by other players, obstructed by other game elements, often appear out of focus, and the players upon whom the tattoos appear move quickly through the game. And so they go over a little bit more about those tattoos, and then the licensing. Solid Oak has not profited from licensing the tattoos. Solid Oak has never created a video game that depicts the tattoos, nor has Solid Oak licensed the tattoos for use in a video game. Defendant's expert stated that he is not familiar with any video game developer licensing the rights to tattoos for inclusion in a video game. And so the judge starts their discussion. We're going to skip past the summary judgment standard. Defendants move to dismiss for copyright infringement, arguing that plaintiff cannot prove its claim because defendant's use of the tattoo is de minimis, as in so minimal that it's not a violation of law, and plaintiff is thus unable to prove the substantial similarity element of its cause of action. In order to establish a claim of copyright infringement, a plaintiff with a valid copyright must demonstrate that the defendant has actually copied the work, that the copying is illegal because a substantial similarity exists between defendant's work and the protectable elements of plaintiffs. To be substantially similar, the amount copied must be more than de minimis. To establish a infringement is de minimis and therefore not actionable, the alleged infringer must demonstrate that the copying of the protected material is so trivial as to fall below the quantitative threshold of substantial similarity, which is always required to show an element of actionable copying. The quantitative component of the analysis concerns the amount of the copyrighted work that is copied, the observability of the copyrighted work, the length of time the copied work is observable in the allegedly infringing work, and factors such as focus, lighting, camera angles, and prominence. Observability of the copyrighted work in an allegedly infringing work is fundamental to a determination of whether the quantitative threshold has been crossed. Substantial similarity must be determined through application of the ordinary observer test, which considers whether an average lay observer would recognize the alleged copy as having been appropriated from the copyrighted work. As noted above, defendants assert that plaintiffs cannot establish substantial similarity because their use of the tattoos is de minimis. In resisting, plaintiff argues that if an NBA 2K player selects Mr. James or Martin or Bledsoe in a given game or series of games, or employs the broad range of the video game's features to focus, angle the camera on, or make the subject tattoos more prominent, the overall observability can be fairly significant. The court denied that motion, saying there was no objective perspective as to how the defendant's video game is generally played, or to what extent certain game features can be or are actually utilized, that would allow this court to make determinations about the choices and subsequent observations of the lay observer, or about the observability and prominence of the tattoos. The court was thus unable to conclude, without the aid of extrinsic evidence, that no reasonable jury, properly instructed, could find that the two works are substantially similar. Here, defendants are entitled as a matter of law to summary judgment, dismissing plaintiff's copyright infringement claim because no reasonable trier of fact could find the tattoos as they appear in the game to be substantially similar to the tattoo designs licensed to Solid Oak. And they go on to say that only 3 out of 400 players appear this way, that the undisputed record shows that average time is unlikely to include players with tattoos, and even when those players are included, the display of the tattoos is small and indistinct, and the tattoos are not featured in marketing materials. They cannot be identified or observed during gameplay. They are significantly reduced in size, 4.4% to 11% of the size they appear in real life. Then there's an implied license discussion. I'm going to guess that this means that because it's a tattoo and it gets inked onto your body, that the player, as in LeBron James, has a right to an implied license that they can then continue to license their own personal likeness, including the tattoo. Remember, in copyright fair use, there has to be a transformation. And so I think taking an image and then putting it on somebody's body has to be some kind of transformation. And unless you're going to take a picture or make a drawing of that tattoo so that you can then make more tattoos outside of the license, that's the only way I think that could be a copyright infringement. Let's see what the judge has to say. A copyright owner grants a non-exclusive license to use his copyrighted work, waives his right to sue the licensee for copyright infringement. The undisputed factual record clearly supports the reasonable inference that the tattooists necessarily granted the players non-exclusive licenses to use the tattoos as part of their likenesses, and did so prior to any grant of rights in the tattoos to plaintiff. So I'm guessing the tattoo artists licensed their tattoo designs to Solid Oak, so that Solid Oak could then sue. That sounds an awful lot like Right Haven or Rights Corp. I think it's more Right Haven. But as long as they did it exclusively, then it is a valid grant. An assignment of copyright or an exclusive license, it sounds like that's not Right Haven or Rights Corp. But it's definitely along those lines. Like it's copyright trolling behavior. Defendants' right to use the tattoos in depicting the players derives from these implied licenses, which predate the licenses that plaintiff obtained from the tattooists. So the licenses were granted after the tattoos were inked on the players. Fair use. And we've gone over fair use before. The 4 fair use factors are the purpose and character of the secondary use, including whether it's commercial or nonprofit educational, the nature of the original work, the amount and substantiality of the portion used in the secondary work in relation to the original work as a whole, and the effect on the potential market, the market usurpation factor. The determination of fair use is a mixed question of fact and law and is a balancing test. The purpose and character of an allegedly infringing use is evaluated by considering whether the new work merely supersedes the objects of the original creation or instead adds something new with a further purpose and different character. To that end, courts consider whether the allegedly infringing use is transformative, that is, whether the two works have different purposes, the size of the reproductions, the expressive value, the portion of the copied material. Here, the undisputed evidence demonstrates that defendants' use of the tattoos is transformative. While they feature exact copies in the game, the purpose in displaying the tattoos is an entirely different purpose from which the tattoos were originally created. They were created as a means for players to express themselves through body art, and they mean the basketball players, not the game players. Defendants reproduced the tattoos in the video game in order to more accurately depict the players. and the particulars of the tattoos are not observable. The uncontroverted evidence thus shows that the tattoos were included for a purpose, general recognizability of game figures as depictions of the players, different than that for which they were originally created. Second, defendants significantly reduced the size of the tattoos. Third, the tattoo's expressive value is minimized in the game. The tattoo images are infrequently and imprecisely displayed. Fourth, the tattoos constitute an inconsequential portion of the game, those .0002 and .0004 game data or gameplay length or something. Last, the purpose is commercial, and as a result, the tattoo's inclusion in the game is also commercial. However, the tattoos are indistinguishable during gameplay. We're going to skip over the nature of the copyrighted work. It has to do with whether they're published, whether they're commercial purposes. The court considers the amount and substantiality of the use, whether the copying was excessive in relation to the valid purpose. Copying an entire work does not necessarily weigh against fair use, but it can. Here, the undisputed evidence shows that while the tattoos were copied in their entirety, defendants did so in order to effectuate the transformative purpose of creating a realistic game experience. Considering this purpose, it would have made little sense for defendants to copy just half or some smaller portion of the tattoos, as it would not have served to depict realistically the players' likenesses. Furthermore, much like the copied images at issue in a different case, Bill Graham, the tattoos were reduced in size, such that the visual impact of their artistic expression was significantly limited. Unlike the images in Bill Graham, the tattoos depicted in defendant's game are not recognizable, reducing further the impact of their artistic expression. Accordingly, the third fair use factor does not weigh against fair use. Effect on the market. The fourth factor considers the effect of the allegedly infringing work on any existing or potential market for or value of the copyrighted work. This inquiry focuses on whether the copy brings to the marketplace a competing substitute for the original or its derivative so as to deprive the rights holder of significant revenue. Here, plaintiff asserts that defendants diminished the commercial value of the tattoo artwork in the marketplace for licensing its use in other works, including but not limited to video games, apparel, and memorabilia. However, defendants' use of the tattoos is transformative. Tattoos, as featured in the video game, cannot serve as substitutes for the use of tattoo designs in any other medium. Indeed, plaintiff has conceded that NBA 2K is not a substitute for the tattoos. Therefore, use of the tattoos in NBA 2K could not deprive the rights holder of significant revenues because potential purchasers of the tattoo designs are unlikely to opt to acquire a copy in preference to the original. For this reason alone, the fourth factor does not weigh against fair use. Further, there is no evidence from which a reasonable fact finder could conclude that a market for licensing tattoos for use in video games or other media is likely to develop. The court may consider only the impact on potential licensing revenues for traditional, reasonable, or likely to be developed markets. Plaintiff's hypothetical market for licensing tattoos in video games or other unspecified media does not satisfy this standard. Defendants have proffered uncontroverted evidence that such a market is likely to develop and that, if it did, plaintiff could not capitalize on such a market because the tattoos are imprinted on the bodies of the players, and plaintiff is not licensed to use the players' publicity rights. Plaintiff has failed to proffer any evidence from which a reasonable fact finder could conclude that a market for licensing tattoos for use in video games or other media is a traditional, reasonable, or likely to be developed market. For the foregoing reasons, the defendant's motion for summary judgment is granted in its entirety, and plaintiff's cross motion is denied. And that is Judge Laura Taylor Swain for the Southern District of New York, I'm guessing? Southern District of New York, yep. So yeah, tattoos are safe. Unless somebody is copying your tattoo for the purpose of making a copy of the tattoo, then it's probably transformative. Then depicting someone in their family setting or their post-game setting, or taking photos on the street, or even making a video game, it's not going to be a violation of the tattoo artist's rights. I frankly thought it was real dumb to bring a case like that. I don't mean to be insulting, but come on, did you really think that you get some special royalties for your tattoo because you put it on a person's body who then is later a very popular person, or even is currently especially currently is a popular, like you knew he was a popular person and you didn't get a higher price for the tattoo or something, or a specific license for the artwork or something like that. Like, so hear me out here. If I go to a tattoo artist and I get something inked on my arm, I don't necessarily own the original artwork. I own the implied license to the copy that's on my arm, according to the judge here. But I don't own the original picture. So if the tattoo artist wanted to sell a license or assign the copyright to LeBron James or one of the other players, that would have been how they could get their money, I guess. But that's not what they did, as far as I can tell here. So that's our show, everyone. I'm Leonard French, your favorite copyright attorney. Thank you to Brandon and Tack for joining me for this morning's show. Thank you for watching this production of Lawful Masses, your favorite legal news and education channel. Please subscribe to our YouTube channel. Please support us on patreon.com/ljfrench and sponsors.com/law. This channel would not exist without your support. We also have YouTube memberships available and Floatplane memberships available, and we're going to be doing more and more exclusive content for our supporters as I get better and better at it. Please send us your suggestions for what you'd like to see as exclusive content, and we'll figure out what to do for you as well. Thank you to our $50 plus supporters in the month of April. Thank you to Wes Delj, Video Quarantined, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Michael Pearce, Jan Negrey, Daniel Perez, Aspernari, Joe Tyson, Benjamin Hitov, Steven, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Nicely Done Defense, Mullen PC, Sean McNamara, Josh Baker, Ugly Grill, Gregory, Shielo T, Michael Moore, and Beastman. I appreciate you all. All the $5 plus supporters are scrolling on the LED panel over here. You'll all appear in the description of the videos that drop. I'm Leonard French, your favorite copyright attorney. Have a good week. Have a good, hopefully, final weeks of shelter in place and quarantine and all that. And I'll try to keep you up in the legal news and education with our channel here. I'll see you in the next one. Love you all. Bye.